Hi there. So what we've looked at so far is to discuss the issues about the elements of a valid contract. Now we want to continue with what we are doing and then look at very key important aspects of contracts, or two things that are very vital in contract, and that is what we refer to as the conditions and then warrants. Very two important terms that we need to understand when we talk about contracts. So what is a condition to a contract and what is a warrant? Simply, we say that a condition is a vital term going to the root of a contract, whilst a warranty is a subsidiary term to the main purpose of the contract. So what does that mean? A condition is the fundamental thing on the contract, the fundamental subject matter on the contract, and then a warrant is like a subsidiary term on the contract. Now, so let me give you a scenario so that you see. Now, if you have a contract with me that I should teach you, and you're going to pay me, right? So meaning that I'm going to be teaching you, and you're going to pay me. So I'll teach you for 3 months, and you pay me $3,000 for the term, all right? And then it is that I'm going to be meeting you twice a week. Twice a week. Now, so if you look at this agreement here, so this is our terms of agreement. I'm going to teach you 3 months. You're going to pay me $3,000, and I'm going to meet you 2 times a week. Now remember, we said twice a week, so we did not arrange any day. But because of how your schedules are and how my schedules are, we said that we're going to be meeting twice a week. Meaning that for this agreement that we've had, or the contract that we've had, the teaching and the payment, that is the objective or the term of the contract, which is the teaching, and then the payment becomes the condition of the contract. This is the fundamental of the contract. So I'm going to teach you for 3 months, you pay me $1,000, sorry, $3,000. This is what we call the fundamental of the contract. Now, meeting twice a week is a warranty, all right? It's a subsidiary term of the contract because we did not fix any date, but we said twice in a week. So teaching and paying the money becomes what? A condition, a fundamental thing, whilst the twice meeting in a week becomes what? The warranty. Now, when we talk about, we will talk about breach of contract in a moment, but one thing that you need to understand is that when it comes to a breach of a condition, usually it nullifies or terminates the contract. But a breach of warrant, the injured party can sue for damages and continue with the contract. What does that mean? If you pay me $3,000 to teach you for 3 months, and I teach you for only 1 month and I stop teaching, then I've breached a condition to the contract. So you can take me to court and demand the court to either pay me, plead with the court to demand me to pay you back your money, or to demand me to teach you performance obligation, or what we call specific performance, specific performance. Now, so with that one, you're taking me to court for me to pay your money, and then we terminate the contract. But then, if we are supposed to meet twice in a week, and then there was a week that we met only once, then we agreed that we are supposed to, we will be meeting on a certain day, then you come, but I don't teach you. So you wasted money, your traffic, your travel, everything to my premises, and you didn't get me, and I didn't teach you, meaning that, and you feel offended. In that case, you can take me to court, but when you take me to court, it is not that they are going to be ending the contract. You're just going to sue me for damages for the fact that I made you travel to the premises without me being there to be able to teach you. So when the condition is breached, usually it results into a termination of the contract. But when a warranty is breached, you sue for damages and you can continue with the contract. So that is what you need to understand about conditions and warrants. Now the next thing we want to look at is discharge of contracts. All right, discharge of contracts. Where is my duster? Discharge of contracts. Now, remember I mentioned this in the introduction video to contracts. When we talk about discharge of contracts, it is simply where the contract comes to an end and all parties to the contract are relieved of their performance obligation. What does that mean? It means that we say a contract is terminated, a contract is discharged when the both parties to the contract are relieved of their performance obligation. So that is what we mean by a discharge of a contract. Now there are various ways through which a contract can be discharged, and we want to look at those ways briefly. We'll talk about agreement. First, let's talk about performance. First one. Second, agreement. Third, we talk about frustration. And then fourth, we can talk about breach. So these are the ways through which a contract can be discharged. A contract can come to an end. The first one is performance. Now this is very simple because performance is where both parties to the contract have undertaken their obligation or responsibility or have performed their duties under the contract. So we say a contract is discharged by performance when both parties to the contract have performed their duties or responsibilities under the contract. So for instance, if you say you want me to teach you for 3 months and you pay me $3,000, if I teach you for 3 months, you pay me the $3,000, meaning the contract has been discharged by what? Performance. Because I have done what I am supposed to do to teach you for 3 months, and you have done what you are supposed to do to pay me $3,000. So that is what we mean by a contract being discharged by performance. The second thing is about agreement. Now the idea about agreement is that, for instance, if the parties to the contract, one of them is facing a challenge or cannot continue with the contract any longer as a result of something that they can't control, then they arrange. So both parties will agree that, okay, because of A, B, and C, let's discharge this contract or let's end this contract. Then we say that the contract has been discharged by what? Agreement. So back to my illustration. You want me to teach you for 3 months, you will pay me $3,000. So if I should teach you for maybe in the middle, I've taught you for 2 months and maybe you've paid me all the money. Then because you pay me money at start before I start teaching, so you've paid me the $3,000, but I've taught you out to 2 months. Then in the second month that we were concluding to go enter the third month, maybe you had a call or you come to me and tell me that, Nhyira, I have to travel, so I need to ignore the cost. So I'm traveling outside. Is this opportunity that I've been waiting for? So please, let's conclude the contract. Meaning, and maybe I should pay you back part of the money or whatever agreement we come on. So meaning the contract has been discharged by what? Agreement. So a contract is said to be discharged by agreement when both parties to the contract come to a mutual understanding to discharge the contract and to relieve each party of their responsibilities or obligations under the contract. Then the third thing is about frustration. Now, what is frustration? In legal terms, when we use the word frustration, we mean events that happened which were not anticipated for prior to the agreement of the contract or at the point of the agreement of the contract. So a frustration can be a change in law. It can be a natural disaster. It can be by death. It can be by any other thing that incapacitates a party from the continuous performance of his or her duty. I hope you get the idea. So if we have a contract that, for instance, so back to our lectures. So let's say A, okay, wants to have a contract with B. Okay, A has a contract with B, and the contract is that A should build a house for B. So A is a constructor, and B is the other party to whom A will be building the house for, or for whom the building is to be built. Then what do? A, they have agreed a contract is 3 years to build the house. Then maybe after 2.5 years, A has had an accident or experienced some ailment, and so become paralyzed and cannot continue with the building of the house. In that case, we will say that the contract has been discharged by what? Frustration. Because it's an event that occurs that prevents A from the continuous performance of his obligation under the contract. And that is what we mean by frustration. Very, very important. So where a performance of an obligation is impossible due to specific circumstances occurring after the formation of contract. So it's impossible to undertake the contract because there are certain events that have occurred after the agreement or the formation of the contract. Then the fourth thing we have there, which is what we're going to be expanding on in a moment, is breach of a contract. Now, we say a contract is said to be breached when a party or one party to the contract fails to meet its contractual obligation. So if a party to the contract decides that, okay, so A is supposed to build for B. A has been building and B decides not to pay A the amount of money that was agreed in the contract, then we say that B has breached what? The contract. So when a party refuses to perform their contractual obligation under the agreement of the contract, then we say that the contract has been breached. So these are the terms or the circumstances under which what? Contract can be breached, or 4 ways under which contract can be breached. So by agreement, by performance, by frustration, and then by breach. So these 4 things are very, very important. Now, so let's spend some time on breach of contract. So when a contract is breached, the one who breached the contract, we say in legal term, has injured the other party. So, because the other party is going to be suffering some loss for the unfulfillment of the promise by the other party. So, what then are the solutions available to an injured party? So let's look at that. Remedies available to an injured party. So remedies available to an injured party. So when an injured party, if a breach of contract occurs, what are some of the solutions available to an injured party? Among other things, we're going to be talking about 5 things under these solutions. The first one is, now, 4 of them are going to be in relation to court. So the first thing is about suing for damages. Suing for damages. So this is where the injured party sues for damages, pleading the court to be indemnified or to be comforted for a loss that has occurred under the contract. Now, usually when individuals sue for damages, it is not that they are really ending the contract, but they are continuing the contract. But there are other cases where you sue for damages and then you end the contract. So that is the first thing that we can talk about, you suing for damages. The second thing is suing for specific performance. Specific performance is where you are still taking the other party to court, but then you are pleading the court to order the other individual to perform his contractual obligations under the contract. So suing for specific performance is where the injured party sues the other party to perform his contractual obligations under the contract. So what does that mean? It simply means that, for instance, if I am supposed to teach you for 3 months, you're supposed to pay me $3,000. I have taught you for 3 months, but you have refused not to pay me the money, right? You refused to pay the money. So what do? I take you to court. When I take you to court, I'm not going to sue you for damages, but I'll sue you for specific performance, so that the court orders you to pay me the $3,000. That is what we mean by suing for specific performance. The next thing we can talk about is suing for injunction. Now, so this is where the injured party, you see, injunction simply has to do with where the injured party obtains a court order to place a halt on an activity undertaken by the other party. So maybe the other party is continually undertaking or performing an activity or undertaking something that hurts the other party. So the injured party now goes to court and sue for injunction to place a stoppage on the continuous performance of the duty. So that is what we mean by suing for injunction. So we can sue for damages, sue for specific performance, sue for injunction. Then the other thing that we can sue for, as we have it here, is to sue for what we call quantum merit. Quantum merit. Now, what is quantum merit? Quantum merit simply means you pay me for what I have done under the contract. Simple. Pay me for what I've done under the contract. So this is where the injured party in a breach of a contract claims the value of their work. Claims the value of their work. I hope you got that. Claim the value of their work. So, back to our illustration. If I'm supposed to teach you for 3 months, you pay me $3,000. I've taught you for 2 months, you've not paid me any amount of money. Then I go to court, I will sue you for quantum merit. Meaning, I will sue you for how much work I have done so far. That's 2 months. So if in the whole 3 months you are supposed to pay me $3,000, we are going to prorate that and find out how much you are going to pay me for the 2 months that I have worked. So you can sue for damages, you sue for specific performance, you sue for quantum merit, or you can sue for specific specific damages, specific performance, injunction, and then quantum merit. Now the fifth thing is what refers to as repudiation. Repudiation. Now, what is repudiation of a contract? In a simple language, that we say that a contract is repudiated. So let me define what is here. It can be defined as a breach of contract which the entities of the injured party end the contract if they choose to. So to repudiate a contract simply means that, all right, there is a breach of contract, but then I have decided not to take any action against you. Sort of literally like Mijaya Manaka. So literally, if we should say that in Chui, I am leaving it for it to be there. I won't take any action about it. I've just decided that they should take the money. So I've taught you for 2 months, you don't teach, you don't pay me. I've just decided I'll stop teaching you, but I will not pursue you for the money. I will not take you to court for injunction, specific performance. I won't sue you for quantum merit. I won't sue you for damages. I will just leave it and allow it to go in relation to that. So this is what you need to understand about the remedies available to an injured party. So let's see what else we have to cover in that place. Now, so What we've discussed so far is to look at the law of contract. We've discussed the elements of the valid contract. Then we've discussed also about discharge of contract. Now the other thing we need to talk about are what we call vitiating factors. Now vitiating factors are simply elements which, when present in a contract, makes the contract not to be enforceable in the law courts. So these are vitiating factors. The first one is called misrepresentation. So what is misrepresentation? Misrepresentation is simply making of a statement by one party to lure the other party to enter into the contract. That is called misrepresentation. So it's a statement made by a party to the contract to lure the other party to enter into the contract. For instance, if I should come and tell you that I am a sales representative for Unilever Ghana Limited, and every product of Unilever Ghana Limited that you want, I can bring it to you. And you see me with a tag, Unilever Ghana Limited, I have the tag. And you see me that I have the goods on me. And so you sign a contract with me and I bring you the goods. If something happens within the two of us and you go to Unilever Ghana Limited, they don't know me as they are represented. So that condition, that situation is what refers to as what? Misrepresentation. So you can't take Unilever Ghana Limited to court, because if you take Unilever Ghana Limited to court, they can't prove. There is no name like that are presented to you as a sales representation or representative of their company in their records. So if you take it to court, you need to prove beyond reasonable doubt that really I was an employee of the company before you can stand a chance of winning. But the objective of misrepresentation is to lure the other party to enter into the contract. So you come, then I have my card, I have my tag, my name is on it, the company's logo, the company's contact, the company's website, but you don't do any due diligence, you don't do any research on it, you don't find anything. All you know was that, yes, you want to deliver products, and quote unquote, I give them to you at a cheap price because I say I take them from the wholesale, then I sell them to you. So one time you gave me money, but I didn't bring the goods. Then you say you go to Unilever. So that is called misrepresentation. When that thing is present, it makes the contract not to be, it may be valid, but will not be enforceable in the law court, meaning it becomes what? A voidable contract. Then the next thing we can talk about is mistakes. Mistakes. Now, mistakes is where a party or both parties in the contract misinterpret a term in the contract. So for instance, I say that I am selling a home appliance. If I'm selling a home appliance, you say that, okay, you will buy. And I'm saying I'm selling a home appliance for 500 Ghana cedis. Then you say, all right, Nhyira, I will buy. Now you send me the money, then I send you the home appliance. The home appliance I was selling was a refrigerator. But you were thinking that I was selling a sound system or home theater. That is what? A mistake. Meaning that each party is given different understanding in a contract. When that thing is there, it affects how the contract can be enforced in the law court, because meaning the terms of the contract were not properly agreed or were not known to both parties. Then the next thing we can talk about is called duress. Now, duress is a direct force that is placed on a party in order for the party to enter into the contract. Now, the opposite of duress is undue influence, which is an indirect force that is placed on an individual to enter into a contract. So let me give you an example of that. If I come to you now and I say you have a land, then I point a gun at you, then I have a document there, then I say, sign that this land is now belonging to me, or you are transferring the ownership of this land now to me. So I want you to sign. Then I put a gun on you and at you and I said, sign. Now when you sign this document and the land becomes mine, you did not enter into the contract willfully, because one of the core elements of a contract is that it should be entered willfully by the individual entering, or to whom the contract is being presented or the offer is being presented. So if I should force you directly like that, point the gun at you and say, sign this document, and you sign it, meaning that even though the contract is valid, you sign it under what? Force that I put, or pressure that I put on you. So the contract is valid but become voidable. Now, if you should take that thing to court, you should be able to prove beyond reasonable doubt that yes, you were forced to enter into the contract. Then undue influence, on the other hand, is when I say that, all right, if you don't sign the contract, for instance, I kidnap your wife and your children, then I tell you, if you don't sign this document, then I'm going to kill your children and your wife, or your children and your husband. In that case, I am still putting pressure on you, but then it is in an indirect way. And so that is what we call undue influence. So these are what we refer to as what? Vitiating factors. When they are present in a contract, they make the contract, even though the contract may be valid, they make the contract what? Voidable, because the people entering into the contract don't have what? Valid understanding of what is happening. Either they are being forced to enter into the contract, or they misinterpret a term in the contract. So when it comes to the law of contracts, these are the things that you need to understand about the law of contract. Now, most importantly, for the purpose of the examination, conditions and warrants is very important. So remember what we said. We said that condition is the term that goes to the root of the contract. The term that goes to the root of the contract. Whilst a warrant is a subsidiary matter of the contract. So you got to make sure that you understand these very well. Then elements of a valid contract, very important area. The examiner is going to be asking you a question on that. Then also the issue in relation to what we talk about in remedies to an injured party in a breach of contract. So these are key areas that you have to focus on when it comes to the law of contract. So I'll see you in the next video as we continue with our lesson and talk about some other things.